All right, beautiful day going on right now. Gorgeous sunshine. We got John King here in the studio. Good morning, Mr. King.
Good morning, Peter.
Get an extra half hour rest, did you?
No, not really. But my
Well,
kids weren't there to crowd me out this morning, so I got to relax a little bit.
Wow.
Yeah, my kids spent the night at Grandma's.
Wow, very cool.
I know, Grandmas are awesome. Everybody should have one.
At least one, yeah. Most of us do, but anyway. All right, well, we've got a special guest in studio. Jeff McLean's joining us. He's the parts manager for Kurtz Polaris, and you are here to talk about the big auction deal going on, right?
Yes. We have in there a Polaris e-bike, which is an electric bicycle. Polaris has been getting slowly into the electric vehicle market, and we have been very excited about this e-bike.
Well, first of all, how does it work? I mean, I realize you still have to pedal it, right?
Is it like a scooter?
So you do. It still has pedals, still has, all the components of a normal bicycle.
So it's like an electric moped, sort of?
Essentially, yeah.
Can you go online with an e-bike? Can you perform an e-trade on an e-bike or email?
That may be in the future.
Okay, cool. I'm glad you guys are working. Someone needs to be working on that.
Yes.
Although, if you were to try to email on your e-bike, you would be distracted driving.
Also, yeah, you could get in
course.
trouble in Missoula for that.
Yes.
Anyway, so please, we interrupt you all the time.
Oh, that's all right.
Go ahead.
So it's a very neat little machine. It's got an in-frame 30-volt battery that powers a 450-watt motor that's located in the rear tire.
Wow.
Or rear rim. Mm-hmm. With that, it's got a thing called duo drive, which means it's going to sense the terrain that you're on and how much input you're putting into the bike based on how fast you're pedaling, how hard you're pedaling. And it's got a few different assistant modes that's going to give the motor more or less power to kind of help you along.
So let me ask you this: if you've been biking, riding for a while, you're just tired. Can you just turn it on and it'll go for you?
You definitely can.
Okay.
It's got a throttle as well. So you can push that throttle and it'll go up to 20 miles an hour.
Really?
It's got a range depending on rider size, conditions of somewhere between 15 and 30 miles.
Now, when you're pedaling, are you powering the battery, or do you need to plug this thing in?
It does require to be plugged in. It uses a normal 110 household electrical outlet to plug in. Charge time is about 6 hours on it. And they guess about 6 hours on average, depending on the rider.
So now, what do these guys run? If I wanted to go out, if I wasn't lucky enough to get it out of the auction, what do they run?
You're looking about $2,500.
Okay.
For one of these e-bikes.
Well, but then this is a bike crazy community. I would think that they'd be flying off the shelves here.
They are something pretty new to Polaris. We're definitely very excited about it. The Missoula seems like the perfect community for something like this, with as many outdoor enthusiasts and folks that just like to do anything they can to reduce their carbon footprint.
Well, now, allow me to ask you, because it's electric, it doesn't pollute, okay? So the bicycle purists aren't looking down their nose at an e-bike, are they?
I don't believe so.
Because I don't put too much past the bicycle purists. I think they look down their nose at everyone, but maybe that's just me. Maybe I'm being too insulting. I don't know.
I was just thinking, I don't know if I would have an electric bicycle.
It's the Missoula aristocracy.
Yeah, because I'm just kidding. So tell us more about Kurtz Polaris. What else do you guys have?
We sell kind of the full line of Polaris off-road and snow vehicles.
Snow?
It's something that normally happens this time of year.
I think you can do it in Chicago right now.
Yeah.
Go to Boston. Yeah, you bet.
Head that direction.
You bet.
We are a dealer for Climb winter apparel, very popular, durable, lifetime guarantee apparel.
And keep you warm, right?
It guaranteed to keep you dry,
right.
Keep you warm.
Oh, super.
Very cool. Now, all that stuff, well, obviously you can find it in the store, but the e-bike is on the iHeart Missoula or iHeart Montana auction right now.
Right, yeah.
I'll be posting a link there. There's lots of other stuff, 50% off, a whole bunch of different goods, including childcare. I noticed there was massages and spas and a whole bunch of other stuff. And then there's a whole bunch of auction items, big things like the e-bike that we were talking about. And those auctions end on Friday.
Right. So you got to get your bid in, right?
Of course.
But bid is not like voting where you can only vote once. You can bid early and often, right?
Right. It's more like Chicago. You can vote as many times as you want to, as long as you're not. Well, you can be dead too.
Yeah,
so
exactly.
No holds barred.
So tell us, Jeff, where Kurtz Polaris is located
Kurtz
now.
Polaris is located on at 2904 West Broadway. That's kind of right between Wayland Tire and Les Schwab Tire. We are open 9 to 6 Tuesday through Friday, and 9 to 5 on Saturdays.
Super. Well, it's a pleasure meeting you. Thanks for coming by.
No problem. Glad to be here.
Next time, bring the bike and you can ride it around
Of course.
the studio.
That would be
Even better, we can watch Peter try to run a machine.
Yes.
Which is hilarity at its best.
Are the spokes nice and sharp so I can cut my fingers off? I'm really good at injuring myself. Let's put it there. There's a history here. So
When he signed his next contract, there's actually an exemption for any machinery besides recording studio equipment.
Thanks a lot. All right. Hey, it's a pleasure. Thanks so much for stopping by.
Thank you.
All right. We're going to take a break, and when we come back, we are going to be visiting with an attorney, right? Hertha Lund.
She's a property and water rights attorney. She's been doing water rights and property rights in Montana for much more than a decade. I don't recall exactly when she started, but she is one of the preeminent supporters of the CSKT Compact.
Okay.
And I have her as a recommendation for the show from a number of legislators, people that are involved in government, who think that she is probably the best presenter of the case for the CSKT Compact. So you'll be able to hear that right after this break.
Yeah, but the reason we're having her on is because a week or so ago we had some gentlemen in who were irrigators who were steadfastly against the compact.
But kind of try to play the pro-con,
We're just trying to do the whole
thing.
balanced and approach thing, which we try to do here on Talkback. So we will get with Ms. Lund from the Lund Law Firm, by the way, out of Bozeman, and we'll be right back in a moment. And we're back on Talkback. 721-1290 is the number. John King is right there. I'm Peter Christian. Joining us on the phone is Hertha Lund from the Lund Law Firm out of Bozeman. And first of all, Hertha, thank you for taking time out of a very busy schedule to visit with us this morning. We really appreciate it.
You're welcome. I think that this is an important issue, and I'm happy to share what I know to help people make a better informed decision.
All right. Before we get too far, I'd like to kind of give you some time to explain who you are and your background in property rights and water rights in Montana. And also just kind of tell the audience we have an article that Hertha has written for us, an op-ed that's up on our Facebook page. If you want to go there and check it out, you can get some background for her, maybe during commercial breaks. Of course, you're so busy listening, it's going to be hard to read while we're actually talking. But.
Well, we're all going to be sitting on the edge of our seats, and John and I are standing.
So Hertha, tell us a little bit about your involvement in property and water rights in Montana and why the CSKT Water Rights Compact is so important to you.
Well, I'll start back in the early 80s when I went to college here in Bozeman. I was going to be a veterinarian. I also had I went to horseshoeing school. And the reason I went to horseshoeing school is because we lost our ranch in the early 80s. We got caught upside down when property rights fell. And so I went to horseshoeing school and helped pay for the rest of my school by bartending and shoeing horses and managing ranches. And during that time, I decided that I didn't like what was happening with this federal government and the Endangered Species Act and different issues. And I started writing, and people said, you should become a writer. And so I thought, well, okay. I wanted to help keep other ranches and people viable in their small businesses in Montana. So I went back east and went to school at Temple University in journalism. And the reason I went back east is I thought, if I don't like how people are coming in to tell us how to do things, I would be equally as ignorant if I didn't go try to understand how other people thought and why they were so passionate about the public lands and the federal lands in Montana. So I went back there, got a degree in journalism, did different jobs, and ended up covering Congress for the American Farm Bureau Federation, where I worked on property and federal lands issues. And while I was there, I covered the United States Supreme Court as a journalist, and a trilogy of takings cases were heard, and I got to cover those as a journalist. And I decided I did not want to just be a journalist. I wanted to be in the mix of it, so to speak. So I came back to Montana and went to law school. And after law school, I went back to D.C. and clerked for the Chief Judge of the United States Court of Federal Claims, where all takings cases are heard. And while I was in chambers, he heard some of the first water rights takings cases. And after that, I've been across the West working on behalf of agriculture, and I was recruited into Washington in the early 2000s to work on the salmon issues to protect agriculture there. So I have a long history of working on property and water rights, and I'm a little bit of a nerd in that I've written law review articles on the parameters of a Western water right and the property interest in a Western water right. So that kind of brings us current to today, and most of my practice is working for farmers and ranchers on condemnation issues with real property, our water rights, and in the water court.
Now, one of the things that I think is interesting about you is not only do you deal with water rights, but you deal specifically with Montana water rights coming out of Bozeman. And I would assume, I'm definitely not an expert here, but I assume that water rights are kind of perniciously different from state to state.
They are. I've actually written law review articles on the differences or kind of the property interests in the different Western states. And the Western states have what's called the prior appropriation doctrine. The eastern half of Montana, since they have, our United States, since they have more water, has a different doctrine for water rights. In the West, where it was more scarce, all the states adopted the prior appropriation doctrine. And California kind of did it one way, and Wyoming another way, and Montana is kind of in the middle of those. And Colorado is the most established as far as their property rights system, and they also have a different way of administering those water rights. So all the western states are a little bit different, and then our Montana Water Use Act is very unique also.
Well, I know that you have a pretty good history in water rights, and one of the things that you came and wanted to be involved with in this conversation was the CSKT Water Rights Compact in particular. So I wanted to start throwing you some questions, and I'm sure this is where we'll get callers. So if you have a question or a comment for Hertha, please feel free to give us a call at 721-1290. She's willing to take calls from anybody. Let's just start things off, because one of the things that I've heard over and over again as one of the main arguments against the Water Rights Compact is a sense that the Water Rights Compact would take away sovereignty from the state of Montana and divvy it up to either the tribes or even, I've heard arguments, to the federal government, and that this is not only against the state constitution, but it's against what would be good for Montanans. So I would like if you could just kind of take that question or that position and unravel it for us as you see it.
Sure, and now this is really hard. When you start talking about constitutional law and sovereignty, there's all types of doctrines. So I'm going to try to, hopefully I'll speak clear enough and I can get it out of my head and so people can understand it. But the first thing you have to look to in Montana when this question comes up is the Greeley case. Now, a lot of people think that since they can read, we're the age of the internet, and people think that since we have an internet connection, we're doctors or lawyers. And the reason that people go to law school is you have to learn how to read and weigh the different things. And one of the most important things, if an issue's been decided, is to understand the case law. And in Montana, we have a 1985 case called State of Montana Greeley versus actually the Confederated Salish and Kootenai Tribes of the Flathead Reservation. And in that case, the court looked at the history of Montana, and one thing that the proponents of the compact totally miss when they get this argument is when Montana, the Enabling Act of Montana, actually sets out, and I'll read it the exact language, it says that the people inhabiting said proposed state, Montana, do agree and declare that they forever disclaim all rights and title to all lands owned or held by Indian tribes, and that said Indian land shall remain under absolute jurisdiction and control of the Congress of the United States. That was what Montana had to agree to become a state. So the sovereignty argument is not about giving up Montana's sovereignty. The argument that the courts have actually looked at is whether or not the United States had to give up sovereignty so that the state of Montana could even adjudicate the water rights on the reservation. So it's exactly the opposite of what most people are talking about. The state of Montana has never had jurisdiction over the tribal lands, and the issues that we're talking about. It's a question of whether or not the federal government has given it up enough for even our Montana Water Court and our Montana legislature to adjudicate those water rights.
Now, Hertha, one thing that we had some folks from an irrigators group that were here about a week ago, and they, of course, steadfastly opposed the Water Rights Compact because their fears, and one of these gentlemen is actually a tribal member, the other lives on the reservation, was that they were convinced, and they were really quite passionate about it, that should this be ratified, that their water rights that they've been using for multiple generations would eventually end up with them having no water and no value to their land because the water would be basically strangled from their properties over a period of time. So how do you respond to fearful charges like that?
Well, I certainly can understand that, and I work for property owners all the time, and there's nothing they need more than certainty with their water and their land to be able to stay in business and stay viable. However, in this circumstance, it's exactly the opposite. They would have more certainty with the compact than without, and let me explain that. I know a lot of people, and I hear a lot of discussion about federal government control over Montana's water, and I've heard people think that the compact with no compact actually helps us from that. Again, the opposite is true. Not having a compact will give the federal government more control over Montana's water, and there's multiple reasons. If the tribe files, which they have to if the compact fails, then let's say it's 10,000 claims. It could be fewer or more. Then the United States government has to defend and pursue each of those claims in the water court. So that means when I defend landowners across Montana, which will be two-thirds of Montana, I now have to defend against the United States and the tribal government because the federal government has a duty pursuant to statutory law to defend all their rights. So now I'm fighting the guerrilla of the federal government on these water rights. Furthermore, each one of these claims would be an in-stream flow right. And what happens now in the Montana Water Court is that if there's a claim out there for an in-stream flow, it can allow other people to piggyback onto those and cause mayhem, such as, for example, environmental groups who currently have no in to get into the issue of in-stream flows on the eastern side of Montana and on the western side. If the United States has to defend these claims for the tribe, then we will have 10,000 opportunities, or at least that many, for environmental groups and others to piggyback on those claims to enforce in-stream flow rights.
Okay, now hold on just a second, Hertha. I'm so sorry. I'm kind of the commercial sheriff, so I have to jump in here and take a break. And we have everybody who wants to visit with you as well. Greg is on the line with you. We also have a line that is being filled right now. Hertha Lund is joining us. She's an attorney, a pro CSKT water compact. And so Greg and Tom are both waiting to visit with you. We'll be right back. Talkback rolling right along. Peter Christian, John King, and this is our short segment. Hertha Lund joining us. She's an attorney in Bozeman, working actually speaking on behalf of the CSKT Water Rights Compact. So lots of folks want to get in with you, so we have a short segment here. Greg, you are on with Hertha. Please go ahead, sir.
Yes. Can you hear me?
Yes, sir. Go ahead.
Yes, I'm a dairy farmer up in St. Ignatius, Montana, and I support everything Herschel has said. I think she's doing a fantastic job. We need the compact for certainty. And one thing that hasn't been brought up that the compact doesn't even address, but it brings closure to the fighting and bitterness between neighbors that's been going on for the last 2 years with accusations that aren't true. If the compact will bring, at least stop the bleeding. It won't bring healing overnight, but at least stop the bleeding. That, to me, is one of the big important things that it can do, along with giving us the certainty of our future and our water and everything else. We rely 100% on irrigated ground, and so the water compact is very important to us, and we support it 100%.
Hey, Greg, have you always been a supporter? Have you changed your mind, or what's been your path to this point?
I've been a supporter since it started. I think every time that they've sat down at the table, it has got better and better for the irrigators, and I think it is just a fantastic agreement right now. And sure, there'll be flaws in it and stuff, but I have no doubt that they can be worked out later on. The basic principles are there, what we need to move forward with.
Okay, Greg, thanks for the call. Tom, you're on Talkback. You have 1 minute. Please go ahead, sir.
Okay, real quick. A few things I'd like clarified. I've been led to believe that the compact affects the drainages of all the drainages of western Montana, including non-reservation waters. Also, I'm been led to believe that it affects subsurface water. Is that going to affect my ability to drill a well on the piece of land that I own next to mine? Will I have to go to the tribes to get this permission and to pay for a permit?
Okay, thanks, Tom. So, Susan, what do you think? I'm sorry. Hertha, what do you think?
I need to ask one more question. Are you on the reservation or off the reservation?
I apologize. I hit his off button. I'm sorry. Tom, call us back. Call us back.
I can
Let's
answer
assume that. Why don't you give it both ways?
Yeah, both ways.
Yeah. So if if the gentleman is off the reservation, the fact that the tribe has in-stream flow rights will help him. The one thing that a lot of people don't understand is what is an in-stream flow right. They're different. They're a new creation in the past several decades, and a lot of it started because of the free market and wanting to be able to sell property interests and water rights so that if people wanted to use water for environmental concerns, they would have to pay for it instead of just regulate it. So we do have the ability for in-stream flows in Montana, which is in the last several decades. It wasn't originally that way.
Okay.
But an in-stream flow right means the water has to stay in the stream.
Okay, we got to take a break. I'm so sorry. And we're going to come back. We have the whole 9 o'clock hour to visit with her. Susan, I'm going to ask you to hold, and we'll be right back. Okay, we continue now with our conversation with attorney Hertha Lund, who's calling us from her office in Bozeman, talking about the CSKT Water Rights Compact. Now, we had a gentleman on, Hertha, who has wanted to find out what's going to happen to him if he wants to drill a well on his property, whether it's, and didn't keep him on long enough to find out whether he was either on or off the reservation. So if you could continue with that, we'd appreciate it.
Yes, it would be beneficial. The compact would be beneficial to him whether he's off or on the reservation. The reason is if he's off the reservation, the in-stream flow right that the tribes have would keep water in the stream, which would mean it would not be taken out of the stream and consumed. So anything that keeps water in the stream to when it flows off the reservation onto his property would be a good thing for anybody who's off the reservation. So the other thing is if you're on the reservation, currently you have no ability to legally drill a well. So with the compact, you would then have a legal ability to drill a well. So all in all, you're much better off with the compact if and their in-stream flows in his circumstance.
Okay, let's get to the phones and talk with folks been waiting a while.
Susan, who has a Patience Award, I believe.
I'm
now.
sure she does. Susan, first of all, thanks for holding. You're on Talkback. Go ahead.
See, I'm an irrigator on the Flathead Indian Reservation, and I want to know what kind of protections I have as an irrigator.
Okay. Hertha, what are the protections for irrigators?
With the compact, the protection for irrigators are that they actually now have a delivery right, which they didn't have before. All the other irrigators in Montana who are on Bureau of Rec or Bureau of Indian Affairs projects have no delivery right like they have in this compact.
Can you explain real quick, just for us that don't do irrigation, what is a delivery right?
It is a right that they can pass on with their property. Currently, if you're part of a federal project, you kind of share all the water with everyone, and the courts have said that you may have somewhat of a contract right to get the Bureau of Rec or Bureau of Indian Affairs to deliver a certain amount of water, but it's kind of nebulous. In this case, because of the compact, people like Susan have an enforceable right. Furthermore, the compact, as it was negotiated, and a lot of what they spent this last summer on, because I worked on behalf of irrigators on the reservation with the state of Montana, we put into the compact itself ways to help ensure that those irrigators there get their historic use of water, which they do not have those protections without the compact.
Susan, you have any more questions?
I was just wondering if you have a feel for, I know that the Joint Board has come out against the compact. Do you have a feel for how many irrigators are in support of the compact on the reservation?
I know that I work for many of the irrigators up there that are very concerned about the Joint Board's position, because the Joint Board position has the ability to assess them charges on their acreage, and then they use that money against the irrigators' wishes, and they didn't allow them to vote on it. And it's my understanding that the majority of the large landowners who make a living in agriculture and want to pass on their places to their kids to support the compact, and they have no idea why the Joint Board is so hard and certain that it's a bad thing, when in reality it's what's best for agriculture. It's my understanding on the Flathead Irrigation District that 3 of the board members support the compact, and they have, I think, about 1,200 acres, and the 9 members who don't support it only have 1,300. So as you can see, a majority of the acres probably support the compact.
Now, real quick, just for my background, when it comes to that board, Hertha, do you know if it's like do they do polling, or is there a vote en masse, or is it just a representative system there?
Right now it's a representative system. I know that one of the board members wanted to take this issue to the members, and they had it lined up for a vote, and the board pulled it off the calendar and never allowed the membership to vote.
Hey, Susan, anything else for Hertha before we let you go?
No, thank you so much.
Thanks for the call. And that means we have a line open, and that means Sheila is on. Good morning, Sheila. You're on with Hertha Lund. Go ahead.
Hi, I just have a couple of questions, and I appreciate your time. 58 members of the Crow Indian tribe have filed suit, and they want legal representation that would defend individual reserve water rights that have been allotted to the tribe in the Crow Compact. Well, individual water rights are going to be allotted to the tribe in the CSKT Compact, if I'm not mistaken. And I could be, but I don't think I am. So what's the difference? You're representing water rights, individual water rights against the compact, and over here, you're representing water rights to go into the compact.
Okay, so Hertha, if you could sort that out for us. Thank you, Sheila.
Sure.
Thank you.
Sheila, thank you so much for the question. What she's bringing up is I do represent some allottees, which are Indian landowners on the Crow Reservation, and in that case, we've argued that the compact and the federal government did not take care of their rights, and the issues are exactly the same. If the Crow Compact had in it what's in this CSKT Compact, my clients would have no issues, except for how the federal government treated them in the process, which is another issue. But they are exactly the same. I'm on the same position. I am for property rights, and there is nothing in the CSKT that takes away a property right. And in fact, I've written extensively on that there is no takings in this compact.
Okay, we're up against a break. So, Catherine, if you don't mind holding, and we appreciate, again, Hertha Lund. She's with us. We have one line open. You can also make your views known on our Facebook page. We'll be happy to pass those along to Hertha as well. So we'll continue. She's very kindly consented to be with us all the way till 10 o'clock. So if you have a question or a comment, pick up the phone and give us a call at 721-1290. Hey, it's Talk Back, and we're rolling right along. Hertha Lund is our guest, an attorney from Bozeman, and we have a Facebook comment.
Yeah, we've got a couple Facebook comments, so let's get into those. First off, Elena wants everybody to go and read the Western Montana Water Rights website, which she says has more info than just threats and intimidation. She also says that there is a bill out there, so let me read this. Hold on, I got to open up the link here. Okay, here we go. For your information, important notice with exclamation points to the end of the line. Representative Bob Brown out of Thompson Falls is carrying a bill, HB 427, that provides an alternative to the CSKT Water Rights Compact. If the CSKT Compact does not pass, he is asking for $13 million to assist Montana with protecting the state-based water rights of citizens throughout the state. Should this tribe come to follow through with their aggressive 10,000 claims threat throughout the state. $13 million is a far cry from giving away $55 million of state taxpayer dollars, all the water and state jurisdiction over the water of Western Montana. We urge your support for this bill. So I don't know. Have you heard anything about this bill? This kind of ties into what you were saying earlier about the extreme costs of fighting the lawsuits when the federal government, environmental agencies, and the tribe are all involved.
Yes, and first, there's several problems with that bill. First of all, on the monetary issue, $13 million is not even a drop in the bucket. I did very conservative math on what individual water rights holders would have to pay for private representation, and I came up with $1.7 billion.
Oh!
And I think that that's magnitudes of 5 less than what it would really cost. And so, and furthermore, you can't require the federal government to help people with their property rights. I mean, the only reason we got public defenders is because the Supreme Court said that when there was a case that could take away your life or liberty, those types of issues that are criminal, that just because you were indigent didn't mean you couldn't have representation. So they're going to have constitutional problems with that bill. It's not enough money. And lastly, I think the last person you would want to have represent you on your water rights, since it's a very narrow niche of law, would be a public defender.
Okay. Let's get back to the phone and say good morning to Catherine. Catherine, thanks for holding. You're on with Hertha Lund.
Good morning. Good morning, Hertha. The EPA is writing regulations that assert federal authority over all water sources, navigable or not. How will these regs affect the compact, specifically senior water rights, and which entity is ultimately going to be in control?
She's talking about the stuff that's going on in Washington, D.C. with the...
Navigable waters, I think, is the...
Yes, and it's...
Expanding the definition of navigable waters.
It's horrible. I mean, I've been involved on these issues for 20 years when I used to work in Congress or with the American Farm Bureau to work on legislation. This has always been one of our issues. In fact, we fought against what was called the glancing goose test, which means that if a goose flew over your property and it looked like a wetland, it probably was. We rolled that back with litigation and legislation, and now this current administration is trying again to expand it. That is a separate issue than the compact, but the compact would expand the reach of the federal government through the tribe's filings on those 10,000 claims all over eastern Montana. So you would actually have multiple layers of potential issues with the federal government's impact on Montana's water rights if the compact doesn't pass.
Well, if the compact does pass, where would the EPA stand in asserting federal control, especially if the tribe then turns around and gives them the water rights or the authority to the federal government?
Well, first of all, I guarantee you that this tribe will not be turning over anything to the federal government. I mean, I think that they would take great umbrage to the very thought that they are the most sophisticated in all the issues I've done on Endangered Species Act with different governments, different states, in Washington State for years litigating the salmon issues. This is by far the most sophisticated tribe that I've ever dealt with. They have the best people on staff, and I can guarantee you they have the ability to protect their water rights.
So would that be, would that then be in the compact itself, that the rights would not be turned over to the federal government for...
Well, the federal government can't take their rights by law. However, there's a nuance. The federal government has to defend the tribe's rights, defend the tribe and their rights through their trust duties. So there is no provision that allows the federal government to actually totally take control of the tribe's rights. And
so
in fact,
do I hear, let me see let me reflect back at you. What I hear you saying is, in order for the federal government to take the rights away from the tribes, they would have to defend the tribes against themselves.
It'd be a breach of their trust position.
That is, the last one is correct. They cannot take it, and if they did take it, the tribe stands just like us, and they've been to the United States Court of Federal Claims, and where the government has taken their property, the government has to pay for it. So in a situation like this, the tribe would sit exactly in the shoes as one of my landowners. The government can't take their property because they'd have to pay for it, and then there's another layer. The government has to defend the tribe's rights because of its trust duties.
Right. So anything else, Catherine?
No, that's it. Thank you.
Thanks for the call. All right, 721-1290 is our number. Anything else on Facebook?
We do. Hold on. Okay. Let me get let's do a call because I got a call coming in.
To the phone. All right. Let's get Paul on the line. Paul, first of all, thanks for holding. You're on with Hertha Lund. Go ahead.
I have a couple of things, if you will let me hang on for a little while.
Right ahead, sir.
Okay, in Article 4, Section 4 of the United...
Now, just keep in mind, Paul, we have to take a break in 2 minutes, but we will hold you over, so go ahead.
All right. Article 4, Section 4. The United States shall guarantee to every state in this union a Republican form of government. I would like your attorney to clarify whether that means each person or a select group of people that are guaranteed this Republican form of government.
Now, but what does this have to do with the compact and what we're talking about?
People under jurisdiction of the tribes that aren't going to have anything to say about it.
Okay, so Hertha, did you want to respond to that?
Yes, and this is again where it gets very complicated. The courts have been very clear that if you're on the reservation and you're a non-Indian, they don't have jurisdiction over you, like for criminal issues and different things. However, they do have jurisdiction over land use issues. In fact, I think the CSKT tribe actually has taken over the ability from the federal government to enforce, I think, the Clean Water Act. So they step into the shoes, and they're more similar to the state government in certain situations and not in other situations. So they don't have, I think, a way to put it easily to understand is they don't have personal jurisdiction over non-Indians, but on a lot of issues they have the right, just like when you go into the Marr County, where my husband's ranch is, the county has jurisdiction and they have the right to regulate that. When you step onto the CSKT reservation or any of the other reservations in Montana, you have multiple layers of government. You have county, you have tribal, and you have the state. And so, the jurisdiction, you go there. It's not like they come and get you. You go there. So if somebody bought property there, they bought into the situation where they were within the tribal jurisdiction on certain issues.
Okay, we have to take a break. Paul, we're going to hang on. We'll let you ask one more question when we come back. We also have Rena on the line and Facebook, so we're going to come right back. Oh, we have way too much fun when we're off air. 721-1290 is our number, 1-800-568-5309. We appreciate Hertha Lund being with us, and we're going to give Paul one more question before we let him go. Paul, please go ahead, sir.
Okay, I would like to know who's paying this woman's salary, whether it's the tribe or the ranchers, and if either way, if she's been talking and saying she's representing both, isn't there some kind of a absolute conflict of interest?
Okay, so we'll answer that. So if you don't mind, Hertha, I realize it's kind of a personal information, but if you don't mind answering that question.
Well, quite frankly, I haven't been paid for a couple months, and I'd like to know who's paying me too. And my client, though, in this case, are irrigators, farmers and ranchers, and their supporters on the CSKT reservation. And, that is my client. That's who I work for. But I would go on one step further. I've been in this practice long enough that I don't have to represent clients that I don't believe in their cause. I've represented Montana agriculture and landowners for more than 20 years, and I think this is best for Montana, and you could not pay me to say anything that I think would oppose Montana ranchers, farmers, and ranchers.
I promise not to pay you, Hertha. You're not going to get a cent out of me.
Trust me, the check's not in the mail. All right, let's get back to the phones. Say good morning to Rena. First of all, Rena, thanks for holding. Go ahead.
We got another alignment.
Good morning. I was listening to the testimony at the Capitol on Monday and trying to understand what the functional, objections were on the ground. And it sounds like this compact converts agricultural water to the in-stream flow that you had mentioned earlier, and that those irrigators up there that did speak against it were concerned that their allotment or their amount of water would not be enough to sustain their current operations. And the other quick question, I know you read the part out of the Montana our statehood Act, but the original treaty, has it ever been adjudicated that the right to hunt and fish included the right to the water?
Hey, Rita,
Yes.
thanks for your call.
Are you talking about, I assume, the Hellgate Treaty?
Yeah.
Yes, and those are really good questions, and it shows that she's really paying attention. What people got to remember with water rights is that just because you have a water right, it's not like real property. There are different attributes, and one of the main attributes is whether or not you're junior or senior. And that means that if your water right, if your ancestors put it to use in 1908 and your neighbor's ancestors put it to use in 1933, the one who has the earlier water right gets to have their water instead of you getting yours. So it's first in time, first in right. And in this case, the courts have been very, very clear, and it's in this Greeley case that the tribal rights are either from time immemorial or from when the reservation was set aside. In this case, it predates, the settlers or their ability to have the water. And there's another complicating factor is that in this case, if the individuals had tried to get a water right it would be junior to the tribes. So you have to have seniority and a property right. So the tribes have the senior right, and what the compact does is they are asking for water for fish in-stream flows. And the compact makes sure through various different mechanisms that the in-stream flow rights are going to come from making the system more efficient. Right now it's a leaky irrigation system. So the goal is to put the water that's now being leaked out, is not going to the farmers and ranchers, to be able to clean the system up, fix it, so that water can more efficiently get to the landowners, and any saved water or salvaged water will go to the fish. And then she asked about I think what was the last question?
It was about the Hellgate Treaty and whether or not that had been judged on by the Supreme Court to expand what are read, I think the wording is hunting and fishing rights, hunting and fishing into what we are now talking about water rights.
Yes, and that is, in Montana, that case has not been decided on point. In the Greeley case, the Montana Supreme Court discussed that, and it was in dicta, which means it wasn't the main issue of the case, but in their dicta, it indicated that they thought that based on federal law and other states' laws and United States Supreme case law, they did talk about the right to hunt and fish. That issue has been decided affirmatively on behalf of the Indians, the Indian tribes in Washington, and that case has been ongoing for numerous years, and I can guarantee you that in Washington, when it comes to fish, water for fish, tribes, or agriculture loses. So the Compact Commission, in its wisdom on this point, I don't always agree with them. I think they made the right choice to try to negotiate these, because instead of having 10,000 of these claims, there are now 8 off reservation and the ones that they share with the state of Montana.
Okay, and with that, we're going to take a quick commercial break. Gloria and John, go ahead, John.
No, let's go to break.
We have some Facebook comments as well. Hertha, we're going to keep you busy, young lady, and we're going to come right back. Hertha is an attorney in Bozeman, and we're talking about the CSKT Water Rights Compact. We had some folks on last week that were steadfastly against it. Hertha is pro-compact and explaining her reasons. So if you agree or disagree, give us a call. Talk back. Rolling right along. 721-1290 is the number. John King's over there. I'm Peter Christian. Hertha Lund is an attorney from Bozeman with us discussing the CSKT Water Rights Compact. And everybody wants to talk with Hertha. Do we have any Facebook
We
comments?
do. Let me read. Jeannie has a linguistic analysis.
All right.
This is actually one that was posited by a caller last week. Here we go. Jeannie says, a caller a couple of weeks ago noted that there are certain words to look for when someone supports the compact. So get ready, Hertha. You probably have your spreadsheet of words that you're supposed to use out in front of you right now.
You're talking,
and we're going to call you out on it right here.
I
One of these
failed
words.
to get that handout.
Yeah, one of these words is forward. I just heard a caller today supporting the compact, and he used the word forward. I believe that the thought behind this is that there is an ideology behind certain language in supporting a variety of issues. For example, there are 2 instances of using forward in the compact radio ad. Does your guest know anything about this idea? I know it seems irrelevant, and maybe it is, but maybe it is. So, what do you think? Is there a conspiracy behind the word forward? Is there a tactic here?
Well, I'm sure there's conspiracies all over the place, but in this case, I didn't get the memo. But I would say that if it's used in the ad, I bet you they did some market research, and I would say that, I give myself kudos because I didn't do market research and my gut told me the right word to use. So I guess I'm doing okay.
Here's an easy explanation for those out there that might be curious whenever they hear the word forward. What's your alternative? Backwards, right? Everybody knows that's bad, right? So that's why they use the word forward, because
it puts them in backward before.
Well, and not only that, but forward. What was it? Lean forward or move forward?
MSNBC's slogan. Also, the President Obama campaign slogan.
Yes. And because of that, it has to be.
How progressive of them.
Conspiratorial. All right, let's get back to the phone. Gloria, first of all, thanks for holding. You're on with Hertha Lund. Go ahead.
Good morning. I was at the hearing on Monday.
Now, Gloria, can you speak up really good and loud? We're having trouble hearing you.
Sorry.
Go ahead.
Can you hear me now?
Yes, go ahead.
Good.
I was at the hearing on Monday, and clearly I feel that it was unfair. There were about 8 to 10 lawyers as proponents for this. Also, the people that are on farm, and I wrote an article that the Missoulian censured, but the Great Falls Tribune printed, and so did the Farm News in the Flathead. And so there's a lot of truth that people need to know about. There are a lot of state experts, and they craft their statements. But the big thing is, this compact is so thick that committee did not have time to read it. And this is a lawyer's delight, because it's all legalese. And there were more opponents to this bill, and we did not all get a chance to speak. Fortunately, I was there at about 7 or 7:30. Many of us rode the bus all night to get there, and were really, I think, treated badly. Some of the committee members got up and left the room, didn't even listen to testimony, especially when the opponents got up. One thing that hasn't been clearly defined is the tribe's quantified water rights. Basically, there's nothing new in this, and I don't even think the tribal leadership has had a chance to read the compact. I don't have a law degree, so I can't fire back much like Hertha is able to do, and she's very intelligent, and I appreciate her.
Gloria, real quick,
side.
because you kind of said that there's these two sides. I would like to hear from you. What is your biggest reason for opposing the contract or the compact? What have you heard that really triggers your response there?
The tribe is being taken advantage of by our federal government, and they are wards of the federal government, and nobody's going to win in this, but the irrigators are losing out, and I think it's a violation of private property rights. And being through adjudicated water here in Missoula, I know that you can easily be reduced as far as your water rights. And, when you do have decent water rights and then you are reduced to junior water rights. So this is all legalese, and I think it's more simple. And if the lawyers weren't involved, I think everyone would get along nicely. But and it's true. And I love law. I wanted to be a lawyer. I was in pre-law. But I think everything here is totally wrong, and it's designed for lawyers and all these different agencies.
I don't think there were any lawyers present when Cain and Abel were around.
That's true, and I agree with that. So I'm sorry, but we were treated badly. We weren't all allowed to testify, and there was always the threat of a lawsuit. And this is our society today. Now, if our state has to be governed by lawyers and our country has to be governed by lawyers, we have slipped to an all-time low. With that, I will just hang up and let
Thanks for your call,
Hertha
Gloria.
say what she has to say.
Thank you, Gloria. Appreciate it. Go ahead, Hertha. What do you think? And in 1 minute, we have to take a break, so go ahead real briefly.
Well, first of all, it should be known that Senator Vincent tried to have the meeting, the hearing at a time where everybody would have more time to be heard, and that wasn't allowed. So he tried very hard to make sure everybody had time. So it's unfortunate that they didn't have enough time for everybody to be heard. Having said that, we're a nation governed by laws, and that is what we have instead of fighting hand to hand or something. And that is the beauty of America and our whole system that was put together by the founding fathers and our Constitution and everything that's there. So, unfortunately, I sometimes don't like lawyers either, and wasn't it Shakespeare that said "damn lawyers" or something? So, I'm
first kill all the lawyers. Yeah,
ranch girl, and I understand those feelings, but lawyers are trained on how to interpret laws and how to work this process, and I can guarantee the caller that if the compact doesn't pass, she too and everybody else will have the opportunity to pay an attorney. And I'm actually arguing against my own self-interest. If this doesn't pass, I win. I can expand my firm because there aren't enough water laws to help get this through the water court.
Okay, we're going to take a break and come right back. And 721-1290, we have John and then John. Who has some Facebook comments.
Go team! We could be like Power Rangers.
The three Johns.
We're going to be the Orange Ranger.
We'll be right back. Hey, this is Talkback. 721-1290 is the number. John King's over there, and joining us on the phone is Hertha Lund. Now, we do have some Facebook comments.
Well, kind of. Actually, I wanted to spin a question off of what Gloria said because I didn't think it was addressed very well yet.
All right.
One of the concerns that we have, I think, in the American Republic these days is a distaste for gigantic pieces of legislation that few people have read. For a lot of my listeners, the linchpin in this argument or this animosity will be the Affordable Care Act.
Right.
And people like Nancy Pelosi saying, we gotta pass it before we know what's in it, find out what's in it. And a lot of people are looking at this Water Rights Compact, they're seeing how big it is and associated documents with it, and they're saying, no one could really get through all this, and we're going to be sold a bill of goods that we find out later is going to hurt us.
Right.
What's your approach when you hear people taking that line?
I understand it totally, and it is a big document to read. I've been involved with it for a year and a half, and this compact has not changed in many places from the old one. There are only a few places, so if you really wanted to understand it, you had a couple years to read the other one, and then you could go to the places that have been changed and focus on that. So there's a little bit of a red herring that it's so big because most of it's the same as it was before. And then those areas that have changed are significant and help agriculture. And this is a compact to resolve water rights, and it is complicated. And the reason that our Montana legislature did that is so I guarantee you that the case law that will happen if this doesn't pass will be many more pages and will take many decades and cost much more. So the question is not is this big and complicated, it's the question, the delta is, do you want to throw it to the courts, have them work on it, throw it back, and in this case we'd be going to the Water Court of Montana, the Montana Supreme Court, the Federal Court, and United States Supreme Court from both avenues. So it would be many, many more pages of issues and documentation if it's litigated. So that's kind of the argument's not posited correctly when you just talk about it being a big, complicated document. It's what it would be without the compact.
Right. Let's get back to the phones and get our callers who've been waiting. John, number one. Good morning, John. You're on Talkback. Go ahead.
Good morning. That's exactly what was on my mind was the sheer size of it. When you have a bill proposed in front of you that you don't have not only time to read, 1,500 plus pages. If you don't even have time to read the bill, how the hell can you vote yes or no? So on that premise, from studying the in-stream flows off-reservation, I'm going to the Blackfoot River in particular, 9 out of 10 years, the Blackfoot River is below the in-stream flow that's being proposed in that document. Now, I just want to know, on off-reservation, does the 1855 Aboriginal in-stream flow right take precedence over the irrigation rights off-reservation?
Okay.
Well, the simple answer to that is if the water court finds that they have an 1855 water right, which, you have to go to a lawyer probably to get a risk analysis about what might happen in this jurisdiction. I happen to think, based on my years of experience in litigating these issues, that it's more likely than not that they would get the water right, and then they would be senior. And on the question about the Blackfoot River, I'm pretty sure that's one of the shared rights, and so I think that in-stream flow right is already there, and the compact leaves it as status quo.
But the water right that they're using on that shared right is in 1905 or 1904, 1907, something like that. But if this goes back to the 1855, and there's 1855 language in that document, I know that.
Which document? The compact?
The compact, yes. That's what we're talking about, is the compact. That 1855 Aboriginal in-stream flow right is in that document.
And who's to know what the 1855 water flow was? I mean, is that even possible to determine?
Therein lies the problem. If we do regular adjudication in the court, like, say, my husband's property, if we want to argue with the neighbors or the federal government, if they were close by and could make a claim, we argue with affidavits of somebody who was there. My husband's uncle is still alive. He's in his 90s, so he can actually remember and talk about how they use the water. You rely on aerial photos and different things that the water reports from the early 1950s or 40s. There was documentation. For back that long, we have no proof. So it's kind of like arguing about what the dinosaurs did. You can only do it based on historic,
right.
So you're willing to take a chance on this compact passing, and that 1855. Here's the deal: if it goes from a 1907 to an Aboriginal 1855 water right, the shared right, that's going to take precedence over every irrigation right in western Montana. So are you willing to pass that bill to find out whether that's going to come up? Like you said, Obamacare, look what's come up after that's been passed. This is the same thing. You don't know what's going to come up 20 years from now.
Well, hold on. Give her a chance to respond.
Well, go ahead, Hertha. And thanks for your call, John.
I'm actually looking at the compact while we're talking, and I'm trying to find that exact right. I don't think you have your numbers correct, but I guarantee you that the risk is greater to have this out there and let the courts decide it, because the United States Supreme Court has said over and over again that when you interpret Indian treaties here's a quote, Indian treaties must be liberally construed in the favor of the Indians. That's the United States Supreme Court. Our Montana Supreme Court has used that language. If you ask the courts to interpret this, it's highly likely that it will be more liberally construed on behalf of the tribe than it is under this compact.
Okay, we're going to take a 1-minute break, and we're going to come right back. So, John and Alan, and we have another Facebook comments. We only have like 8 minutes left in the show. It's just flown by, and we'll be back with more with Hertha Lund in a moment. Time rapidly slipping away here on Talk Back, and we appreciate Hertha Lund being with us from Bozeman. She's an attorney. We're talking about the CSKT Water Rights Compact. Let's try to get as many calls as we can. John, real quickly, you're on with Hertha Lund. Go ahead, sir.
Yeah, 2 quick questions, 2 quick answers.
All right.
This group Farm, in all their print and voice advertising, they call it the Montana Water Compact, and it's the CSKT Flathead Reservation Compact, so they lie. And as a lawyer, what do you think about this group lying about by not calling the compact by the proper name in all their advertising? That's my first question.
Okay.
Well, I don't know if it's a lie. I call it the CSKT compact. I think they obviously believe that Montana is a better word. It is the only compact left in Montana, so it's a fair assumption that if there's only one left, when you call it the Montana compact, it means Montana.
A little artistic liberty maybe there.
Quite the spin. Yeah. Anyway, another thing, the tribe threatens 10,000 water right lawsuits east of the Continental Divide, which is bogus. The former retired head of the water court said it's bogus. He said they can file all the claims they want back there, but they won't get a one. But it's just a threat to make legislatures vote for this thing.
Is that your question?
Yep.
Okay, thanks, John.
Oh. And that's a position shared by lots of people, including a lot of the people on Facebook that I probably won't get to. So if you could respond to that, the feeling that it's a hollow threat.
Oh, it is no hollow threat. And I'm actually the one who started the 10,000 number. The tribes didn't threaten that. On behalf of my clients, I wanted to know how many potential claims were out there, and I pinned down one of the tribal attorneys and said, well, how many do you have prepared? And they said around 10,000. So I'm the one who started that. They did not threaten it. They have a duty by law to file in June of 2015, just like every other citizen in Montana had a duty to file in the 80s on their water rights. And this is when their date is, because the legislature said we're going to give you more time because we hope to resolve this by compact rather than you have to file. So that is not a threat. That is they have the duty to file. They say they have 10,000 ready at least. I think they have that many or more. And I guarantee you, if I were, going to make money off of this, I would jump up and down and say, pass this, don't pass it, because I'm going to build a business on it. It is not an empty threat. It is the reality. And so Mark Twain once said, it ain't what you know that gets you in trouble. It's what you know for sure that just ain't so. So those people who are spreading rumors that this is a idle threat, they are simply wrong. They do not know what they're talking about.
Okay, let's get Alan on the line. Alan, first of all, thanks for holding. Go ahead. You're on with Hertha Lund.
Yeah, good morning. I've got 2 questions also. The first question is, how are the tribes getting around Article 1 of the Hellgate Treaty?
You'll have to help me with that.
Say again?
You'll have to help me with what is in Article 1.
Article 1 says, the Confederated Tribes of Indians hereby cede, relinquish, and convey to the United States all their right, title, and interest in and to the country occupied or claimed by them, bordered and described as follows to wit, and I won't read that.
That's a very good question, and it's a very good example to show why you're reading the treaty. I'm reading the cases that have interpreted the treaty, and the the Montana Supreme Court has already said that they indicate that the tribe has fishing and hunting rights. So if you were on the court, you probably would have decided that case differently. But the court.
Okay, hold on. We're both talking at once here. So, Alan, finish your point.
That may be true, but if I buy a fishing license, that doesn't give me the right to the water.
Okay, go ahead.
I don't know how that's pertinent. I mean, when you bought a fishing license, you don't have a treaty from back in the 1800s with the United States Supreme Court, the Montana Supreme Court interpreting that, and and talking about your rights and the fact that the law has to be interpreted in your favor to have those rights.
I'm talking about Article 3, where it says the exclusive right of taking fish in all streams running through or bordering the reservation is further secured to the said Indians, but it's in common with the citizens. But my last question, which I think is more important, let's say this compact passes, and it turns out very badly for the people of Montana. What's our recourse?
I don't know how it could turn out badly for the people of Montana, because the reason we have a compact is to settle all these claims, and it makes them defined. They are defined. They'll be less defined without it. So I would do the counter question: if I'm right and you're wrong, how are you going to provide money to all the landowners and water rights holders in the 2/3 of Montana to have to defend their claims?
Well, I could turn that question right around back on you. If I'm right and you're wrong, where's the money going to come from? Because there's going to be lawsuits.
The delta of mistake is much less with the compact than without the compact.
If they take my water with the compact, I'm going to sue.
Good, because you have that right
Who's going
with
to
the
provide
compact.
my money now?
You have the right, and I guarantee you that you can get to the courthouse steps. I don't think you'll get very far into the courthouse because the doctrines of law are against you. You have to have a property right that was taken, and in this case, if you do have a water right, it isn't being taken by the compact.
I believe Article Amendment 14 says equal protection under the law, and this compact seems to violate equal protection under the law.
Okay, Alan, unfortunately, we're out of time. We appreciate your call. We have about 1 minute, Hertha, so real quick, can you wrap up for us?
Yes, I think those who dislike the compact and they seem to dislike the federal government are very unaware of the fact that the drastic, horrible impacts the Endangered Species Act, which we haven't talked about, would have if the compact isn't passed. Currently, the federal government is standing back, and they're relying on the science and the improvements to the irrigation system to be able to meet the needs for a biological opinion for the bull trout. If the compact doesn't pass, and we're back to the drawing board, and we'll have a biological opinion process and the right of environmental groups to enter and mess around with our property rights in Montana for decades. So my closing statement is that without the compact, it would put the federal government's ability to control Montana and its environment on Viagra.
Okay. All right. Hey, Hertha, thank you so much for being with us. We appreciate it. We look forward to having you on again.
All right. We'll be having Alex Apostle, Superintendent for School District 1 here in Missoula, on tomorrow. And I think I also have another special guest written on the board, but I can't read it from here. So
Let's see.
guess they're not that special.
Monica Lundeen?
Oh, no, that's an interview after the show.
Okay.
Never mind.
All right. Listen, you guys get out there and enjoy the sunshine, and I hope you're less confused about the compact than you were. All right, if you are, then we certainly did our job. So.
Frankly, we don't care. Just call in.
Have a great day.